In the United States District Court for the Northern District of Georgia, Atlanta Division, United States of America versus Quincy Williams, to the above named defendant. By direction of the Honorable Mark H. Cohen, United States District Judge, you are hereby ordered to appear in the United States District Court for the Northern District of Georgia, Wednesday, July 9, 2026 at 10 a.m. for imposition of sentence on that date. Report to the United States Courthouse, Courtroom 1905, 75 Ted Turner Drive, Southwest Atlanta, Georgia, where sentence will be imposed. You will receive no further notice. If you are under bond, your failure to appear for sentencing on this above date will result in the forfeiture of your bond. It is further ordered that a pre-sentence investigation and report to this court will be completed and that you report immediately to the United States Probation Office of this court for interview and further instruction. Then it says date, April 1st, 2026, defendant Quincy Williams, counsel Alexis Levine, Michael J. Antonelli, Zachary Finland. So that's, I don't know who that is, Drew Finland, but that's Drew's people. Lisa Enix, and no continuance can be granted except by order of the court. Any request should be brought to the court's attention as soon as possible by having your attorneys call Lisa Enix, courtroom deputy. Peewee Longway just escaped a life sentence. Let's get into the details. Guilty plea and plea agreement. United States District Court, Northern District of Georgia. United States Attorney for the Northern District of Georgia and defendant Quincy Williams enter into this plea agreement as set forth below in the Part 4 pursuant to Rule 11 of the Federal Rules of Criminal Procedure. Quincy Williams, defendant, having received a copy of the above numbered indictment and having been arraigned, hereby pleads guilty to counts 1 and 5. Admission of guilt. The defendant admits that he is pleading guilty because he is in fact guilty of the crimes charged in counts 1 and 5. It's Wednesday. You already know, man. Free cash is setting age. Hey, bro, all you got to do, hit that QR code and tap that link in the description. Get paid to play today. Yeah, that's all you got to do, man. Just hit that QR code and tap that link in the description. Number 2 in the Apple Store, number 3 in the Google Play. And y'all know what we do. We keep it real with you. Read the reviews before you even download it. Once you download, we're going to put $5 in your account. You're going to get paid to play games. So watch this video, play some games and get paid. This is going to be your second stream income. Earn up to $500 a month. I got y'all. Free cash, setting Nash. No better name in the game. Let's get on to count. As to count 1, conspiracy to possess with the intent to distribute a controlled substance. Maximum term of imprisonment, life. Mandatory minimum term of imprisonment, 10 years. Term of supervised release, 5 years to life. Maximum fines, $10 million. Due and payable immediately. Full restitution due and payable immediately to all victims of the offenses and relevant conduct. Mandatory special assessment, $100, due and payable immediately. Forfeiture of any property constituting or derived from proceeds obtained directly or indirectly as a result of the offense, and any property used or intended to be used in any manner or part to commit or to facilitate the commission of the offense. As to count 5, possession of a firearm by a convicted felon. Maximum term of imprisonment, 15 years. Mandatory minimum term of imprisonment, none. Term of supervised release, up to 3 years. Maximum fine, $250,000. Due and payable immediately. Full restitution due and payable immediately to all victims of the offenses and relevant conduct. Mandatory special assessment, $100 due and payable immediately. Forfeiture of any property, real or personal, involved in the offense or any property traceable to such property. The defendant acknowledges that he is not subject to a consecutive 60-month sentence pursuant to count 4 of the indictment, which alleges a violation of 18 U.S.C. Because the government agreed to dismiss count 4 against the defendant understands that before imposing a sentence in this case, the court will be required to consider, among other factors, the provisions of the United States sentencing guidelines, and that under certain circumstances, the court has a discretion to depart from those guidelines. The defendant further understands that the court may impose a sentence up to and including the statutory maximum as set forth in the above paragraph, and that no one can predict his exact sentence at this time. That sounds insane. Removal from the United States. The defendant recognizes that pleading guilty may have consequences with respect to his immigration status if he is not a citizen of the United States. So we just going to go ahead and skip that part because I don't need to read that he is a citizen, man. You know what I'm saying? Consequences are subject to separated proceeding. And we go to 4, plea agreement. The defendant his counsel, and the government, subject to approval by the court, have agreed upon a negotiated plea in this case, the terms of which are as follows. In TV, well, we've always seen it as the hammering out phase. They say, oh, we're going to hammer out the details and all that crap. That's essentially the details on which they're hammering out. There's a lot more to get to. If y'all can't hit that like button like you like something, no harm, no foul. If you don't, just something to consider. But that's the hammering out phase where they're trying to basically get to it. The thing that's hidden there is that there were 2 indictments, and they went ahead and dismissed a whole nother one. Now, obviously, supersede indictments and all this shit, the part 1 and the part 2 of it, with the additional charges that they add. So Peewee basically like, this car about to crash, it's only so much I can fight. I got a feeling in my back corner, bro. Yeah, let me go ahead and see what type of deal we can do. Some people believe that just because you signed your plea deal, it means you lost. But you're talking about facing a life sentence. I don't know if that qualifies right here. He might actually be all right with that. Right. Dismissal of counts. The government agrees that upon the entry of the judgment and commitment order, any and all remaining counts in the above style case still pending, any case whatever still pending against the defendant shall be dismissed. So he got a couple of cases dismissed pursuant to standing order number 7-04 of this court and the rule 48A of the Federal Rules of Criminal Procedure. The defendant understands that the probation office and the court may still consider the conduct underlying such dismissed counts in determining relevant conduct under the sentencing guidelines and a reasonable sentence under Title 18. So the United States Attorney for the Northern District of Georgia agrees not to bring further criminal charges against the defendant related to the charges to which he is pleading guilty. The defendant understands that the provision does not bar prosecution by any other federal, state, or local jurisdiction. So when y'all holler all this double jeopardy BS, this is in plain terms telling y'all the state or any other jurisdiction can come get his ass. It's called dual sovereignty. Have a good one with that one. Based upon evidence currently known to the government agrees to make the following recommendations and or to enter into the following stipulations. Base/adjusted offense level as to count 1. The government agrees to recommend it, and the defendant agrees that the applicable offense guideline is section 2D1.1. The base offense level is 36. The criminal activity undertaken by the defendant and others acting in concert with the defendant involved in at least 30,000 kilograms, but less than 90,000 kilograms of converted drug weight, all of which was reasonably foreseeable to defendant. Defendant receives the 2-level upward adjustment pursuant to section 2D1 because the defendant possessed a dangerous weapon. As to count 5, the government agrees to recommend and the defendant agrees that the applicable offense guideline is section 2K21, acceptance of responsibility. So they just got him to admit, you've been pushing weight. We're going to get rid of this. We're going to get rid of that. And it's the same playbook that we've told y'all on the channel, which other people have experienced all the time when they go through all of this shit. The feds are going to throw 1, 2, 3, 4, 5, 6, 7. They're going to throw so many charges on you. The sentencing, the mandatory minimums, all of this shit, bro. It's scary when you're looking down at it. I don't give a damn what nobody say. It's like y'all coming home and you looking at the fridge and you're like, damn, should I eat this can of sardines? Should I eat these oysters? Or should I just pack it up and eat this cornstarch? It's all bad choices, but you got to pick one. So he just put his hand in the fridge and said, I'm going to take this one right here. Remember, if he would have went to trial and lost, it's possible he would never see the light of day. Now, granted, he's 41 years old. But you still get a freaking release date that ain't going to throw you all the way to the wolves. I know that sounds insane to say, but consider the alternative. Let's finish up. The government will recommend that the defendant receive an offense level adjustment for acceptance of responsibility pursuant to Section 3E1 to the maximum extent authorized by the guideline. However, the government will not be required to recommend acceptance of responsibility if, after entering this plea agreement, the defendant engages in conduct inconsistent with accepting responsibility. Thus, by way of example, only should the defendant falsely deny or falsely attempt to minimize the defendant's involvement in relevant offense conduct, giving conflicting statements about defendant's involvement, fail to pay the special assessment, fail to meet any of the obligations set forth in the financial cooperation provisions set forth below, or participate in additional criminal conduct, including unlawful possession use of a controlled substance, the government will not be required to recommend acceptance of responsibility, right to answer questions, correct misstatements, and make recommendations. These parties reserve the right to inform the court and the probation office of all facts and circumstances regarding the defendant in this case, and to respond to any questions from the court and the probation office, and to correct any misstatements of fact or law. Except as expressly stated elsewhere in this plea agreement, the parties also reserve the right to make recommendations regarding the application of the sentencing guidelines. The parties understand, acknowledge, and agree that there are no agreements between the parties with respect to any sentencing guidelines issues other than those specifically listed. Right to modify recommendations. With regard to the government's recommendation as to any specific application of the sentencing guidelines as set forth elsewhere in this plea agreement, the defendant understands and agrees that should the government obtain or receive additional evidence concerning the facts underlying any such recommendation, the government will bring that evidence to the attention of the court and the probation office. In addition, if the additional evidence is sufficient to support a finding of a different application of the guidelines, the government will not be bound to make the recommendation set forth elsewhere in this plea agreement, and the failure to do so will not constitute a violation of the plea agreement. Sentencing recommendations. So the government basically says this: if you accept this and accept that early on, we're not going to try to nail you to the cross, for lack of better words. So if you came in and they said, oh, bro, you facing 20 years, but, we basically will judge you upon sentencing on the points that you have. You know good and damn well you don't want all them damn points on there. The more points, the worse it gets. So by accepting that early, they knock off some points. And that's where they slight way get you right there. Some people don't truly understand that part, but that's one of those things that persuade people into going, you know what, instead of fighting this, let's just hammer out a plea agreement. I'm going to go ahead and accept shit, but we're not going to go ahead and waste time in the courtroom and all of this shit. And the courts, for whatever reason, they love that. But let's finish up this video, because I know y'all can't wait to get to the meat and potatoes, right? Specific sentence recommendation. Unless the defendant engages in conduct inconsistent with accepting responsibility as described more fully in paragraph 17, the government agrees to recommend a sentence of no more than 168 months imprisonment to be followed by a period of supervised release. The defendant agrees to recommend a sentence of no less than 120-month imprisonment. Forfeiture. The defendant waives and abandons his interest in any property that may have been seized in connection with this case. Defendant agrees to the administrative or judicial forfeiture or the abandonment of any seized property. The defendant agrees to hold the United States and its agents and employees harmless from any claims made in connections with the seizure, forfeiture, or disposal of property connected to this case. We're going to go ahead and skip to page 11. So it says, defendant's cooperation obligations include A, fully and truthfully completing the Department of Justice's financial statement of debtor form and any addenda to said form deemed necessary by the government within 10 days of the change of plea hearing. B, submitted to a financial deposition or interview, should the government deem it necessary, prior to sentencing regarding the subject matter of said form. C, providing any documentation within his possession or control requested by the government regarding his financial condition and that of his household. D, fully and truthfully answering all questions regarding his past and present financial condition and that of his household in such interviews. And E, providing a waiver of his privacy protections to permit the government to access his credit report and tax information held by the Internal Revenue Service. As long as the defendant is completely truthful, the government agrees that anything related by the defendant during his financial interview or deposition or in the financial forms described above cannot and will not be used against him in the government's criminal prosecution. However, the government may use the defendant's statements to identify and execute upon asset to be applied to the fine and / or restitution in this case. Further, the government is completely free to pursue any and all investigative leads derived in any way from the interviews, depositions, financial forms, which could result in the acquisition of evidence admissible against the defendant in subsequent proceedings. If the defendant subsequently takes a position in any legal proceedings that is inconsistent with the interviews, depositions, financial forums, whether in pleadings, oral argument, witness testimony, documentary evidence, questioning of witnesses, or any other manner the government may use the defendant's interviews, depositions, financial forms, and all evidence obtained directly or indirectly thereform in any responsive pleading and argument for the cross-examination, impeachment, or rebuttal evidence. Further, the government may also use the defendant's interviews, depositions, financial forms to respond to arguments made or issues raised sua sponte by the magistrate or district court. So basically, that's it. As long as he discloses all of his stuff, as long as he tells it all as far as what he has and all this shit, it's killing me. They said, bro, you need to drop 10 million immediately, though. They flat out said, bro, send us 10 million right now. I don't know Peewee Longway, ain't never dealt with Peewee Longway. Don't know nobody who know Peewee Longway, but damn, bruh. If they feel like you got 10 million just to give up, I can only imagine. Speculation only. I don't know shit about nothing he got rolling. But I can only imagine how much money you have. The question then becomes, man, and I keep saying this because that's the video that blew up the channel. If you are familiar with the channel for over 4 years ago, going on 5 now, the video that we did that dropped that made the channel blow. It wasn't the Lil Durk video. It wasn't the Quando Rondo video. It wasn't the FBG Duck video. It was the freaking video about Casanova 2 times of you can't have 1 foot in and 1 foot out. So you can be in the streets all you want to, but to indulge in the street shit, that's where people ultimately mess up and they fail. So the video that I'm talking about, that I'm referencing, if you go back and you look, this was the one where I basically said, bruh, if you have 1 freaking foot in the game and 1 foot in the other game, the illicit activities, you're not going to win. Rap doesn't pay everybody because everybody doesn't do good rap business. A lot of these cats will hit some peaks, get some songs that spin, that make them money. They go do features, they go do shows, and they fall in love with the lifestyle that is to be the future. And it turns out there is no future. So they get back to what they know. It's very hard these days for me not to believe a lot of these rappers ain't street dudes when each and every day all they do is show street dudes. It's why people like me, I don't take pictures with people. I don't know who the hell y'all are. Don't want to be that close. So I ask you guys who are watching this right now, what y'all think? Do y'all think he should have fought it? He was looking at a life sentence. Or do you think like me, bro, this is a hell of a deal. You better take this shit. You got caught with 30. And they saying between 30 and 90. So we don't even know. In the drug game, man, what I learned from Freeway Rick Ross, it's only a matter of time until you get caught. That's all that shit is. You're going to get snitches. You're going to get people pulled over. People don't want to do all the crime. And the feds will make it easy. Give him up. We won't take you out of here forever. The guidelines, laws, they're changing to deter people from doing this shit. The only way you can sell drugs in America is if you have a pharmacy behind you. They don't go to jail for the shit and damage that they done to all these people. But your ass will. Fair system, unfair system, it is what it is. Legally sell drugs or get the hell out the game, folks. I can't tell you no more. We're giving these 2 things away at 300K giveaway. We are like 50 subscribers away from 22K, man. I know it seems like it's a slow burn, but we'll get there. Once people start seeing, oh shit, these about to go, and the prices keep raising up, it is what it is. But hey, y'all, let me know y'all thoughts on this one. Click right here, though, to see how Pooh Shiesty ass been in jail since Monday, Tuesday, now Wednesday. What the hell happened? Well, they burst into his daddy's home. Click right here to find out all about that, and click right here for the playlist, and I'll catch you on the next one.